Well, it's been a long time coming for some sort of a legislative response to the scandalous situation that faced the Debenhams workers who were forced to engage in a strike for 406 days because of the absolutely despicable manner in which Debenhams laid them off, made them all redundant, and then refused to honour the collective agreement to give them their 2+2, their 2 week statutory plus the 2 weeks additional per year of service that had been promised in a collective agreement. And that case, but obviously there have been previous cases before it, like Cleary's, like Vita Cortex, like Licenza. There have been a litany of these cases where there were collective redundancies, large number of workers who'd given loyal service to companies who had generated huge profits for those companies, were left absolutely high and dry, and the law allowed that to happen. And in the case of Debenhams, despite a heroic struggle, they got nothing from Debenhams, and Debenhams got away with it. And the public were forced to step in and pay the 2 weeks. The government gave a pretty miserable training fund, but they didn't. They were deprived of their 2+2, and that really was a disgrace when you consider some of those workers had worked 20, 25, 30 years for that company. They received notice via an email, having previously been given commitments and promises by the company that there was no suggestion that they were going to be made redundant, and that it was just COVID that was the reason that they were being temporarily laid off, but then discovered by email that 1,000 workers, all of them, were gone and were being left with absolutely nothing. And I want to commend those workers for fighting an incredible battle for 406 days. To really, much of the battle was not only about their own situation, but was their determination to make sure that it never happened again to another group of workers. Because of course there had been promises after Cleary's with the Duffy-Cahill report and so on, that these issues would be addressed and that other groups of workers would not be shafted the way Cleary's and the others I've mentioned before them had been shafted. And we had many promises by the government during the course of the Debenhams dispute and multiple debates and motions in this House that the issues would be addressed. So, given that's the history, that's the background, while some of these things are welcome, this is an extremely limited bill, and it doesn't really do what's necessary to prevent all of that stuff happening again. As I read it, I mean, we will scrutinise it, no doubt, at committee stage. But the critical issue of changing the order of preference for the creditors to put the workers at the top is not addressed, and that is the key. That is the key change that needs to happen. The idea that the workers who generated the value of that company, who generated its profits for decades and decades, could be left, at the bottom of the list where they don't get anything, or that the company could walk away without honouring their collective agreement for the 2+2. We're not really addressing those things. All we're talking about here, as I understand this bill, the Minister can correct me if I'm wrong, but as I understand it, is that it's requiring that there will be a consultation period. And this 30-day consultation period, and that there clarification that the liquidators would have certain obligations in terms of providing information to workers, and that there will be pretty limited fines if they don't do that. But it doesn't really address the fundamental problem. And I mean, to me, if you look at the Debenhams case, I mean, there was supposedly some level of consultation, but the consultation was a joke. They just told them porkies. You know, for example, they told them that the revenue that the company was continuing to generate, huge amounts of revenue on Debenhams.ie, that money would be available for them to pay for their redundancy, for their 2+2. But what in fact the company had done was ensured that all that money went to Debenhams UK. The company then loaded on, I think it was 200, if I remember correctly, 200 million euro in debt onto the Irish company, essentially meaning that any assets that were remaining in that company were wiped out. And really that was a way of allowing the company, in what was a tactical liquidation, to sell off parts of the company, the Danish wing. There was a group called Glass Trust, I think, were set up, who walked away, hedge funds, a consortium of banks and so on, who walked away with tens and tens of millions, and the workers got absolutely shafted because they were able to do that, manipulate essentially through the different subsidiaries and wings of the company, able to manipulate the financial position of Debenhams Ireland in order to rob the Debenhams workers of their just deserts. So those things are not really being addressed, and indeed they should be made criminal offences. I mean, I think if I read this correctly, and I haven't studied it all in forensic detail, but that workers, if they're not given the proper consultation and the proper information, can go to the WRC. It should be a flipping criminal offence to do what was done to the Debenhams workers. That's what needs to happen. The lies they were told by the company about the financial position of the company. There has to be really punitive measures taken to deal with companies who treat workers in that way. But the critical one, as I've already mentioned, is the one about putting the workers at the top of the list of creditors, so that they can't, because that would change the issue of them being able to essentially manipulate the financial position of the company in order to rob the workers of the proper redundancy entitlements. And of course, collective agreements should be required legally to be honoured, the sort of collective agreements that the workers had, and which led them to believe that they were safe and that they would get their 2.2 in 2+2 in the case of redundancy. So I doubt very much, Minister, that probably the workers haven't seen this legislation yet. I know their film, interestingly, has gained, you should be aware, has gained absolutely massive audiences all over the world. They're in London at the end of this week for the premiere of the film 406 in London, and it's getting huge response. But I think they will be very, very disappointed that this is all the government can come up with in terms of a legislative response to the situation they faced.
Would you move the adjournment, Deputy?
I move the adjournment.